Hi everyone, I'm Jenica with Douglas Elliman. I'm a real estate agent here in San Diego. And today I'm talking with Justin Issac. He is a trust probate attorney in San Diego with Lawyer in Blue Jeans. And I wanted to invite him here today because I find that most homeowners do not have their home in a trust. And it's really important to protect the equity in your home, protect your family, and protect your loved ones. So thanks for coming, Justin.
Thank you for having me. I appreciate it.
So I did not know too much about trust until I met you, I think about a couple years ago. So first, why is having a trust so important?
Well, the main thing is, especially if you own a home, you want to protect your assets and you want to make sure your stuff goes to your family members, to your loved ones, to your friends, most especially not to the government. And if you pass away and you don't have a trust, your assets go through the probate process or the probate court. And essentially your assets are going to be frozen until the court decides to release them. And we were just talking a little bit before we started the webinar, that could be a very lengthy process. Someone asked me one time, Justin, what's this probate going to be like? Because we do probates a little bit on the side. We prefer to do trust, but someone said, what's the probate process going to be like? And I said, well, it's like going to the DMV for 2 years straight. And now with COVID, it's going to be even longer. So an average probate is usually 2+ years. Now we're going to probably approach 3 years. So it's a pretty bad process. And the only way to avoid that is if you have a trust.
That's it. When I first met you, I remember you had told me the average was about 2 years. So adding on due to COVID, about another year of going to the courts.
Yep. Unfortunately, the process is grinded to a halt or ground to a halt because of the whole COVID thing. We don't have a very robust probate system in general due to the amount of judges we have. It's just a slow and bureaucratic red tape. It's the worst of the worst, essentially.
And how many judges? San Diego used to have 2 probate judges, and now there's 3.
That's correct. We have 3 probate judges for 3.6 million people in the county. So we have a judge for every 1.2 million or so people. And the majority of San Diegans are going to go through probate because I think it was an AARP study from 2014 or so. 72% of Americans don't have a trust, which means that 72% of San Diegans presumably will go through the probate process, which that's a lot of people. That is a lot of people.
And that's why I wanted to have you, because I just find so many, even when I'm looking at homes to show or clients buying, most people don't put their home in a trust.
Yeah. There's a problem with a lack of knowledge of how it works in the past, and maybe in even other states, like if you're in, like the Midwest or in the South, it's not as many people. It's not as heavily populated. California, a will is just not sufficient. You're going to go to probate. A will gets probated. The only way to avoid it is to have a trust. And it used to be where you have your property, your assets, and I just signed a piece of paper that says who gets what. Couple of months later, maybe it would be done. That's not how it works anymore. It's not the best route. And it takes not just the time, but the cost of the probate you have to factor in. There's other benefits like capital gains exemptions that we can talk about in a little bit too. So the list of things that you would benefit or your family would benefit from a trust, it far, far outweighs any negatives, which there's not really many when it comes to getting a trust in general.
So even if you have a will, you suggest having a trust as well?
Well, if you have a will, it's going to go to probate. So there's 3 triggers for the need for a trust. If you own property, you need a trust. If you have minor children, you should have a trust. If you have more than $166,000 in total assets, you should have a trust. Any of those 3, not all of those 3, just one will trigger the need for a trust. Most people who get a trust is usually when they get their first piece of property or, maybe a little bit later down the line. But that's like the most concrete need for a trust is if you own property, because you can't transfer that property to your kids, to your loved ones, unless you have a trust or an order from the probate court. And one takes a couple of years, one takes only a couple of months.
Wow. And I was telling Justin before we jumped on the call, I had an experience with a probate situation. I was representing, my client was the buyer, and the seller had refinanced their home and it did not get put back in the trust. So when we were getting ready to close, it could not close. The home had to go to probate court before it could be closed. Due to the home at one time being in the trust, it only took 3 months to figure it out and get in front of a judge, but still it added on another 3 months to close escrow.
So the reason behind that is that you have your trust and that's set up and you're supposed to put all your stuff into your trust. But if you forgot and you had this little outlier that should have been in the trust, but we just forgot about it, we have ways, of course, you know, if there's a problem, an attorney will find a solution somehow. We have ways to get it put into the trust, even though that person had passed away. Now, if there was never any trust, we're on a regular probate. And we just finished, I was telling Jenica off the call too, that we just are finishing a probate for one piece of property going to one child, an only child. We're coming up on 2 years now, and the fees were astronomical, over $25,000. So it's not just the time, but there's also a lot of cost involved in it as well. Jenica, I don't know if I ever told you, we have a probate up in Riverside County that we've been working on for 3-ish years now, where the first executor passed away 2 days before closing, right? And they were supposed to be the one who was going to sign off on the property and, you know, finish the parents' estate. But that executor died right before closing. So we couldn't sell the house, couldn't close on the house. We needed to get another executor appointed. There was only one other sibling, so there's nobody else but that one person. But yet it still took us 10 months to get that person appointed as executor. And we couldn't close on the sale of the house, so we had to back out of the deal. And the house ended up getting burglarized and all these other things that happened because the courts were in control. We weren't. So.
Wow. And that's what I was going to ask you next is how much would you say the average probate costs the homeowner? Not the homeowner, the beneficiary.
Just to give kind of round numbers, like a $600,000-$700,000 probate, if we're just talking about the house, right? And just for anyone's information too, the probate fees are not based on the equity. They're based on the gross inflated value of the property. So if you have a $700,000 house and you have maybe $50,000 in equity, the fees are based on 700 and not 50. And so the fees for a $700,000 probate are around 20,000-ish just to the attorney. By the way, the attorney gets paid before your kids. And not to mention all the fees of processing and all the other things that come with it too. But also it's stuck in probate for 2 years.
Wow. So the courts get paid. You have $50,000 of equity. You're going to give half of that to the court. Yeah. And then the other half will get left to the beneficiaries or your children. Maybe.
Essentially. But that's the thing too, is that maybe there's money owed on capital gains, right? Say you did a refinance and you bought the property at a very low capital gains number and you never put it into a trust. Well, you might owe money to the federal government for capital gains. Whereas if you have your property in a trust, there is no capital gains. So can I give a quick story on this too? Okay. So there was a client who we signed their trust with them, and she called me about a week later, and she had 3 kids, right? Everything was going to one child, and she was disinheriting the other 2. She called me about a week later and said, look, I want to make sure my property goes to this one child. And I said, oh, that's perfect. That's what your trust says. And she said, well, my tax preparer or someone said I should put her on as a joint tenant. So when I pass away, it's going to go directly to her. I said, please don't do that. That could be a huge capital gains issue with your property since you've had it since like 1950, right? She said, okay, I'll think about it. And then we hung up. About 9 months later, I got a call from the daughter saying, hey, look, my mom passed away. And I said, oh, I'm really sorry to hear that. And she said, the government says we owe $80,000 in capital gains. And I said, oh. And I said, did she put you on as a joint tenant? She said, yeah, right before she died, she did. And she's like, how do we avoid this? And I said, you can't, it's too late. We can't put it back into the trust. So that's a very real scenario where we need to be careful about something like that. If you own property in San Diego or California, more specifically, that appreciation is huge. So you're going to definitely want to have it in a trust to avoid the capital gains issue for your kid.
Wow. What happened? Justin?
Yeah, I'm still here.
Okay, sorry. What happened? Wow. So there are tax benefits and capital gains benefits to the beneficiary if the home is in a trust and they are not on title.
Yeah, so we want to make sure that your kids aren't on title to the property or on title to your bank accounts. You want to have your property go into the trust. The terms of your trust will say what happens to that property or to the whole estate, and that's protected while you're alive. And also, after you pass away, there's other protections for your beneficiaries as well. But usually, it's just going to transfer to the beneficiaries. They take title in their name, take it out of your trust, and then they should have their own trust at that point too.
Okay. And what if I have clients that own other properties in other states? So they own a home in San Diego, they create a trust for that home. Does that also cover, can they put their homes in other states in that same trust, or do they have to go to an attorney in a different state?
No, so the one of the good things is that our comprehensive California trust, you can transfer property all over into your California trust, and it's all covered by that too. When you have no trust, you're going to have a probate in every state where you have property, and a probate attorney, assuming as well. So it's a very good tool to kind of to really organize your assets for your trustee. It says who gets what assets you have. It's a flexible document. It could be changed. So if you get a new son-in-law who starts hitting you up for money right away, asking, like, hey, let me get a loan, maybe we'll adjust some things in the trust or disinherit people if they're having problems with substances, or, what if you have a child who has special needs and you finally got them qualified for benefits, government benefits. We don't want them to be disqualified from receiving their benefits by receiving an inheritance. So we're going to structure their share in a sub-trust so they can't touch it and the government can't touch it either. So there's so many different things we can do with the trust.
And so you set up a trust today, and then a year from now, if you want to make changes, you can make changes at any time.
Yes, correct. So most of the time we found that people only change their trust once in their lifetime. So you set up your trust and say you have 2 kids, right? My assets go 50-50 to my kids. Well, you might not change anything there for a while. You might change who's going to watch the kids if they're minors, or who's going to be your successor trustee. Maybe the kids get old enough and you want them to be the successor trustee, so you amend your trust to put them into that position. But if you have a trust that goes 50-50 to your kids, and you just get a new car or a new bank account or something like that, a new property even, you don't need to change your trust, because that's not going to change the 50-50 distribution. That's on a separate sheet where it's called your schedule of assets, and you just list out all your assets, and if something changes, just cross it out, write in a new one. And the goal being to make it a little bit easier so you're not always seeing an attorney to make changes. You can do as much on your own as possible.
Got it. And does that cost the homeowner to make changes to the trust? I'm sure it varies per attorney, but.
Yeah, it depends on the changes. If there's substantive changes like successor trustees or something to the body of the trust, like the distribution, yeah, the changes for that people will charge $200 up to $2,000 depending on the change. But if it's just a car, bank account, asset, you can change that on your own, and those are free. A good attorney will give you that to where you can change it on your own. I shouldn't say a good attorney. A lot of attorneys will have that asset sheet separate. Some attorneys build it into the body of your trust, and then you have to go back and see them anytime you want to make a change. That's not necessary, in my opinion. It should be something you can do on your own.
Got it. And what about if your home's in a trust, you have privacy from who?
Yeah. So essentially, everything is still recorded. Like your property is recorded into your trust. Your trust is not recorded. That's a private document. But your bank accounts go into the name of your trust. And when you pass away, no one gets to know what's in it. No one gets to see it. But if you have a probate, everyone can see what you had. So Prince died a few years back, right? If we wanted to right now, we can go on the website in Minnesota, I think it is, pull up all of his documents, see everything that Prince had, see all the squabbling that's going on within his estate. Same thing with Aretha Franklin. When you don't have a trust, it's in probate and it's public.
I remember you told me that. I'm like, how did Aretha not have a trust?
No, that's what's mind-boggling too, because and it's back in the news recently because Aretha Franklin, one of the kids, I think it was found like a note in her couch that they're saying, oh, this was her will. It was like, I think it was like this big. And it said, essentially like, cutting out 2 or 3 of the kids, right, on this little piece of paper. And now that is being pushed forward as her will to change the whole probate process, and now cut out a couple of kids of hundreds of millions of dollars. I think it is her estate, or like 50, 80 million, something crazy. But you would think that a big celebrity would have a little bit more comprehensive planning in place, but something as small as a handwritten letter can just mess the whole thing up. So it's not a great system, probate. It's kind of antiquated.
Not fun. And how much is it to set up a trust? How much does it cost the homeowner?
That depends on the complexity of the estate. Attorneys out there will charge anywhere from $4,000 to $8,000. If you're in Orange County, it's more like $10,000 or $12,000. Same thing with LA. They tend to be a little bit more costly up there. We don't like doing the hourly fees. A lot of attorneys charge $300-400 an hour. We're a flat fee firm, and we have a good reason for that. Not only because we don't want to hire another accountant to work through all the hourly stuff, but on top of that, we want to have a very open dialogue with our clients. And so if I am talking to you, Jenica, and I press the button and the ticker starts going up, and you know that you're getting charged by the minute, you're going to want to speed through this as fast as possible. Mm-hmm. We might miss something there. And that's not what we want. We want this to be an open communication to where it's not a stressed out environment. And so we charge a flat fee. So our flat fee is blank. And then you and I can just talk without having to worry about the cost incurred or getting a bill at the end or sticker shock at, the last minute. So that's how our business model is.
Okay. And what if someone has just questions on, hey, I know everyone should have a trust, but maybe their situation, what it costs, could they just jump on a call with you and discuss their scenario? Or
yeah, I'm very accessible. Whenever you call or text, I'm always there to answer any questions. I'm happy to do that because this is kind of what we do a lot of. We do a lot of educational seminars. Anyone can always just email me, and we talked a little bit before about anyone who calls from you. Essentially, I'll give them an even bigger discount on our fees. So they can email me, they can call me. Email is always the best because I always have my phone with me, so I can answer at any time. But yeah.
Perfect. And what could you just say your email, and if anyone wants to be connected with him, I'm happy to make the introduction as well.
Yeah. Justin at lawyeranbluejeans.com. The phone number to the office, 619-683-2545. You can go to our website too. You can find all of our information, past videos and things like that on our website, lawyeranbluejeans.com. And then our Facebook is facebook.com/lawyeranbluejeans. So you can see our last webinars on there too. Our, information and all the stuff that we've done.
And I remember when I heard you at one of your seminars, Lawyer in Blue Jeans, it's not for blue jeans, right? It's blue jean law.
Well, there's a whole backstory to that, but it's not necessarily like whenever someone says, oh, you're not wearing blue jeans. I am, by the way, wearing them right now because we're in quarantine, so I'm a little bit more relaxed. But whenever someone says, oh, you're not wearing blue jeans, that's false advertising or something like that. It's not necessarily our attire. It's more how we relate to our clients, how we speak to our clients. A lot of attorneys sometimes get into this mode of talking in legalese and kind of talking down to people. We want to be more relatable, to give you information that's so much more digestible to where you can understand it, because this is not the easiest field of law. This is kind of complex, and this is something we do all the time. So we want you to understand and leave our office not feeling confused or thinking of lawyer jokes, but to think, wow, that was a lot easier than I thought. That is our goal. And I think we accomplished that too. But for the time being, I am wearing blue jeans because COVID. Yeah.
Does anyone have any questions for Justin? I think I did.
Did you hear me?
Yes, hi, Toe.
So I'm not asking about for myself, but for my mother, who I did get a living trust for. Mm-hmm. And you mentioned something about a bank account. Does the bank show that it's in a living trust?
So a bank account should either be titled to the trust or the trust should be the beneficiary.
I think the trust is the beneficiary. Or
Okay.
maybe,
So the reason
okay.
for this, the reason for this is we want it to be pointing towards the trust, because say your mom has a trust and then there's a bank account out here that has no trust information. The trust isn't the beneficiary or the owner. Then as the successor trustee, you have to go through extra steps to get it put back into the trust. Also, if the value is too great, then we have to open up a probate. And that's why you want it in the trust.
So, what about if I am on the account with her? Does that make a difference? Like the bank account with her, does that make a difference?
Yes, that means it is not a trust asset and it won't be bound by the terms of the trust. This is actually something I was talking to Jenica about saying like at the end here too, but if you have a bank account and it's in the name of you and your child, or it's not listed in the trust. So essentially what's going to happen is if your mom passes away, you get to keep the money. You don't have to share it with anyone. Now, if you're the only beneficiary of the trust, then that's okay. But if you have like 4 siblings, your parents probably don't want it to just go to one person. They probably want it to go to, whomever was listed in the trust. So essentially you become the owner of that account.
Would that potentially go into probate is really what I'm going for, because I'm an only child and my dad, so it's just my mom and I.
It would only go into probate if something happened to you and you didn't have an estate plan.
Oh, okay, so I'm good with it the way that it is then.
Yeah, it should be fine. And now, but granted, one thing to know is if you get in a car accident and someone sues you, they can take her money.
She knows that.
Okay, as long as everyone knows that, then that's fine.
And the account has been set up like that for years. So
Yeah.
And before it was just for me to have access. Now it's because she's old and could.
Yeah, there's a lot of good reasons to have something set up like that, but the main thing that I think about is the liability incurred. And if if she knows that it's possible for the whole car accident scenario, which is probably a rare scenario, it's not common. But it's definitely something that our goal is to minimize liability and possibilities of any other issues. So.
Can I ask you another question?
Yeah.
About houses. So one of the things that we did when we got the living trust is we changed the title from my mom and dad's name just to my mom's.
Yeah.
And would it be more beneficial for me to leave it that way so that it would come to me, or would it be better if we go in, refinance, and add me to the trust?
It's in her name and under the trust?
That I don't know. I don't remember.
Okay. Send me an email tomorrow if you want, and I can pull the title on that to see. You're going to want to make sure that it's in her trust name. You probably don't want you on there because you can run into that same capital gains issue that I was mentioning earlier.
Okay. Which
we really want to avoid because it could cost a lot of money.
And that's exactly what I'm looking to avoid. So I guess my question to you really is then, I wouldn't be getting the capital gains once she dies if I'm on the title with her, correct?
No, you would. Oh, I thought you would.
No, you wouldn't be getting the step up in basis that you get with the trust.
Okay.
Yeah.
Okay.
But if it's in the name of the trust, then you get that capital gains elimination.
Okay, so it needs to be in the living trust. I'll need to verify that. To be completely honest, we got the title changed, but I've never filed it with the city or the state or the county.
Might want to do that too. Let's talk a little bit and we can get to the bottom of it.
Okay.
Yeah.
Great. Thank you. Appreciate it.
Not a problem.
All right. Well, thanks for coming, Justin. And yeah, if anyone has any questions or information setting up a trust or just questions, how much it will cost you, Justin's awesome. And just phone call, can do a Zoom with you and get you all set up.
I appreciate it. I think the kind of my closing would be, if you know anyone who has a trust that hasn't been updated or hasn't been looked at for a while, it's a great time to revisit these things. If you know anyone who doesn't have a trust and they're maybe a little hesitant to give us a call or just want to watch information, like a webinar, we've recorded a bunch of webinars about this that I can send to anyone just so you can get an idea of how beneficial a trust is. It's about an hour or so presentation, and it goes into a lot more detail than just what I've mentioned here too. So I'm happy to help. So feel free to email me, justin@lawyerinbluejeans.com.
Perfect. Well, thank you, Justin. And thanks for tuning in, everyone. And have a great rest of your evening.
Thanks, Jenica.